Father, I come before you, Lord. I adore you. I respect you, King of Kings. I put you first in my life. I pray, God, as I do this recording, give me wisdom, knowledge to be able to guide the people who are going to watch this video. Let them be able, God, to listen, take action, and be able, God, to pass their professional exams, professional ethics and practice exams in the April 2025 exams and in future exams, Lord. God, I pray for subscribers and views. I pray all this believing in Jesus Christ, my Lord and Savior. Amen. So I'm doing the recording for November 2023, part 2. Part 1 video dealt with question 1, 2, and 3. And now this is part 2, which I'm going to discuss question 4, 5, and 6. Watch, take action, everything that I'm going to say. Watch all the other videos, and you're going to pass. Professional ethics is the most faced subject in the last 2 years. That is 2023 and 2024. It needs a lot of reading, theory. It's a very theoretical subject, very wide, with many acts of parliament, regulations, international instruments, codes. You need to read widely. Purchase the Q&A in the website. Year 2008 to 2019 goes for 500. June 2021 go for 100. Watch videos from November 2021 paper uploaded. I usually have done part 1 and 2. April 2022 part 1 and 2. November 2022 part 1 and 2. March 2023 part 1 and 2. November 2023 part 1. Now we are in part 2. I usually this subject I usually divided it in 4 parts. Part 1, a very small percentage. You can be asked about a journey of a person to become an advocate. Since I've looked from all the past papers from 2008, which are uploaded on the website, that is a journey of becoming an advocate, the qualification, the degree. So you need to know the Legal Education Act, the Kenya School of Law Act, and look at that question. That is a small percentage. The main questions comes from as after an advocate is admitted to the bar. That is practice and ethical issues, which is last percentage, like 70%. The first part is like 5%. Then there is the third part of when an advocate now join the other professions, become a judge, a state council, DPP, county attorney. So you need to know the various acts of parliament that guide those people, codes. That is like 20%. Then there is what I call the fourth part, the miscellaneous part. These are not purely professional ethics and practice questions. And when I reach such kind of a question, I usually say, so you need to read the Advocates Act to start with. Very, very important, master it. The SOPEC, Standard of Professional Ethics for Lawyers 2017. Those are the like basic minimums. Then you need to read the acts of parliament and codes that guides the other things that I've talked about, and I have talked them in the other videos. So you need to read a lot in this subject. There is no shortcut. It is a very theoretical subject with a lot of reading. Read. Yeah. So we enter into the business of the day. This day, I'm doing this recording on 2nd April 2025. And I'm going to read the question. In an exam scenario, underline the practice ethical issues because not all the facts are relevant to the question. 4A, Nogo, a well-known blogger, has been accused of murder of Lillian, a friend of his. Lillian was found dead at the bottom of an apartment in Nogo resides, directly below the bedroom window of Nogo's 8th floor. Nogo approaches you as a reputed criminal law advocate to defend him in court. Upon evaluation of the charge sheet and the witness statement, you know that the prosecution is relying on circumstantial evidence. Nonetheless, Lillian's death has sparked immense debate on both the mainstream and social media, with journalists, commentators, fellow bloggers, and self-appointed investigators accusing Nogo of heinous and gruesome murder of Lillian in quotes. Upon interviewing Nogo, he admits to you that indeed pushed Lillian through the narrow window opening, but states that he was in state of extensive intoxication, that do not properly comprehend the nature of his action. He said that on that evening, Lillian and himself visited Corrido, a friend in the neighboring apartment, where both served an orange juice distilleries with chemical intoxication known to produce intense loss of normal functioning of the mind after some hours. When they returned home, at some point in course of the night, Lillian woke up and started strangling him. Nogo further explained that he woke up deep in his perception. He was being strangled by a ghost. He gathered all his strength, pushed the ghost from his bed, and forced it out of the room through the nearest outlet, the window. He went back to sleep and was woken up with the following means by loud knocking and shouting by apartment caretaker and some police officer. It was at this moment that, having so bad up, he realized it was supposed that the supposed ghost was indeed his dear friend Lillian. He stated that he had no intention or motive for murdering her dear friend and explained that an unpremeditated killing occurred in instance of his intense intoxication. He further said that a friend who was also that evening confided to him that Corino raised her juice with chemical. He also says that he said that the hatred being propounded in the media was filmed by his fellow bloggers who were envious of him and would not want to have his career thwarted. Your friends and even relatives have urged you not to represent such a person who is accused of heinous murder and that you should guard your reputation. What factors should inform you your decision not to defend Nogo in court? So this is a direct question. Underline the crux of the question. What factors should inform your decision to defend or not to defend Nogo? So Nogo is charged with killing of Lillian. So because of the murder case, the way it was done, people are urging you not to defend him. So what is the case testing about? The case is testing you an advocate representation of an unpopular client. So this is unpopular clients are those who are accused of doing very heinous crimes like terrorism, murder, rape, crimes against humanity, and so forth and so forth. So this question has not been tested since 2008, and this is 2023. So those are like 15, 16 years. So that's why I usually say no, professional ethics is very wide. Yeah. So what is the answer? You give 5 points because of 5 marks. The marks guide you how much you should write. So what are the factors to inform your decision to defend or not to defend him as a criminal lawyer, as a reputable criminal lawyer? Number one, adherence to advocates have a duty, the right to accused to fair trial. That is the first point. Advocates have a duty to ensure that accused have access to fair trial, including those accused of serious crime. The right to legal representation is cornerstone of justice enshrined in laws of Kenya, Constitution of 2010, international law. Yeah, that is the first point. We explain that. Second point, your personal values and moral stance. You reflect on your own moral conviction, defending accused weigh heavy on your concerns, and you're able to separate your feelings from your professional obligation. Is it important to evaluate how it aligns your in your values? Impact on your reputation. Number 3, the case could influence how your peers, friends, relatives, and society perceive you. However, remember, being an advocate often requires impartiality and prioritizing justice over public opinion. Assess whether you are comfortable facing potential reputational risks. Fourth point, presumption of innocence. Remember, under the Constitution and under our rules, everyone is presumed innocent and proven guilty. Ensure that your decision is based on public sentiment or an verified accusation. Upholding the principle of presumption of innocence is central to the legal practice. Point number 5, nature of accusation and evidence. Remember, it's not your role as an advocate to prejudge the case. Understanding the details may help anticipate the challenges and complexity of defense. Yeah, this can guide you in determining whether you're prepared to handle the case effectively. Final point, financial career consideration. Legal cases, particularly high-profile ones, can impact on your career positively or negatively. High-profile representation may enhance your profile, but it could come with significant emotional and professional stress. So those are 6 points, and I have explained them. You get your 5 points. More than enough. Related to this question is question 6A, November 2018, which asked whether consider representing an accused person in a case where I consider defense very weak, thus having a slim chance of success. You can be asked as a question, and the answer is found in page 267 of year 2008 to 2019 question and answer. Purchase and see the answers. Question 4B. Assume that Nogo has approached you, a highly reputable commercial advocate, to represent him in a suit in which he is sued for breach of contract. When you review the court pleadings, you realize that the same were drawn and filed by Katuenza. Your people master some 10 years. You are extremely keen on proceedings with the representation of Nogo in the nature and the matter, particularly based on your opinion that the purported breach is negated by defense of fundamental change of circumstances, despite your former master acting for the plaintiff. From a professional ethics perspective, explain whether it is expected for you to represent and describe how you address the issue. So you're in a law firm where they represented the plaintiff. In this case, now you are called upon 10 years later to represent the Nogo who is the defendant. That's how you interpret the question. 5 marks. So question is testing on conflict of interest and confidentiality. I've told you that this is a compulsory question. Conflict of interest and confidentiality must come in every professional ethics question paper. It's like a compulsory. So you need to understand the law. And I've guided you in the where you can get the law on it. So you give 5 marks, 5 points, give you 5 marks. So representing Nogo in this matter may represent ethical challenges due to prior involvement of your people master Kazuatu in drawing and filing the court pleadings for the plaintiff. First point. The core concern is the possibility of inadvertently using confidential information obtained during your previous association with Kazuatu to disadvantage of the plaintiff. Such an occurrence would lead to legal prejudice, breaching the duty of confidentiality owed to former clients. This principle is supported by case laws such as King Wallen, Miss Limited versus Kaplan and Stratton, a famous case, where the court emphasized that the advocate should not act against a former client in a related matter due to the risk of misusing confidential information. To address the issue, ethically consider the following steps. Disclosure inform Nogo about the potential conflict arising from your former people's involvement in the case. Transparent ensures that Nogo is aware of any other factors that might affect your representation. Obtain consent, seek written consent from Nogo acknowledging that he understands the potential conflict and agree to proceed with the representation despite this. Implement safeguards. Establish internal measures to prevent inadvertent sharing or use of confidential information relating to plaintiff. This may include setting up a Chinese wall with your practice to ensure that individuals involved in our case do not have access to information about the plaintiff case. You explain that, you get your 5 marks. Of course, is a confidentiality, conflict of interest and confidentiality is repeated in almost every past paper. I go to the next question 5, November 2023, past paper. I read, Shupavu Kamili Shupavu is an advocate who practices in the name and style of Saike Law LLP. While reviewing emails one morning, he saw a correspondence with one Muga Orienda, which says as follows. Dear Advocate Shupavu, I have received an attached document titled Notice of Entry Judgment from an advocate acting for a business associate. I was not aware of this court case against me until I received notice. The advocate of my business associate has also stated that they will proceed to execute the judgment if I don't settle the claim of 10 million within 14 days. Please urgently stop the threatened execution of my asset on the basis that I am not aware of the court case and never serve with any summons to appear in court to defend myself. I I want the matter had afresh. Yours faithful Moga Oriendo. Shupavu promptly replied to the email as follows. Dear Muga Orendi, we have taken note of your instruction. Nonetheless, please pay a deposit of legal fees and incidental cost of 200,000. Yours sincerely, Chuchavu Kamili, advocate. Oreda did not pay the stated deposit on legal fees and incidental costs. You underline that. And consequently, Shupavu did not take any action to stay the execution or apply for setting aside of judgment for purpose of a fresh hearing. Consequently, Oreda's business assets were proclaimed and auctioned. Based on the above facts, answer the following questions. A. Assume that Oreda files a suit alleging professional negligence on the part of Advocate Shupavu. Highlight the factors that the court will consider in determining any liability and if established in its extent. So question testing on the elements of for professional ethics, 6 marks, you give 6 points. This question is repeated, same as question 1B, October 2022. Professional negligence, I have discussed it in details in year 2008 to 2019 Q&A, page 150 to 158. Purchase the Q&A and read. So answering this question, in Kenya, the claim for professional negligence against advocates is based on principle lawyers owed a duty of care to clients and that the lawyer's action or omission fell below the standard expected of competent professional. For a claim for professional negligence to succeed, the claimant's issues. So you prove the negligence. So there must be existence of the duty. The first requirement is to establish that the advocate owed a duty of care to the claimant. This is usually straightforward as lawyers owe a duty of care to clients. Providing competent legal services. The duty of care exists when client-lawyer relationship is formed, typically through formal informal agreement where advocates agree to provide legal services. In this case, remember Orienda wrote an email. He was told to repay fees. He did not pay. So you discuss also an offer. An offer was made, but there was no acceptance, so a contract was not formed from the contract. So it fails on the first duty. So you discuss breach of standard of duty. Once the duty is established, the claimant must demonstrate that the advocate breached the duty. A breach occurs when lawyer fails to meet the standard care of a reasonable competent lawyer which provide under similar circumstances. So, yeah, then you discuss causation. The claimant must show that the advocate's breach of duty directly caused harm or loss. Then you must prove 4 actual damage or loss. The claimant must demonstrate that they suffered actual damage or loss. 5, failure to meet the required legal standard. In order to prove negligence, the claimant must please the advocates fail to perform the level expected of a reasonable legal professional. Proof of damages that would have been avoided. Actual damages must be proved. The claimant must show that the damages suffered would have been avoided. So you discuss all those elements. Those are 6, but this case fails on the first because there existed no duty of care, because a client-lawyer relationship was not formed, because Shupavu told Orienda to pay some fees. He did not pay. It was an offer which was not accepted. So there was no contract. You get your 6 marks. Next, B. Suppose Oriada files a complaint against an advocate Shupapu at Advocates Complainant Commissions, ACC, applying the various possible outcomes upon the determination of such complaints. Remember, many questions usually ask on the outcomes that the disciplinary tribunal can give. Now here, this is Advocates Complainant Commission. So you give 4, and the question wanted you to discuss. The question have never been tested since 2008 again. Professional ethics is very wide. So the question required you to discuss section 53, 4, 5, and 6 of the Advocates Act. That's why I usually encourage you, as a basic, what I said earlier, you must read and understand the Advocates Act for you to pass this subject as the bare minimum. So I'm going to share the Advocates Act. So section 53(4), on the screen. So the question is asking you, possible outcomes upon determination of such complaints. So you give 4. Number 1 is found in 53 4A. If it appears the commission there is no substance in the complaint, shall reject. So the first outcome is rejection, 4A. 4B, if it appears to the commission whether after investigation there is substance in the complainant, but the matter complained of constitutes or appears to constitute a disciplinary offense, shall further refer the matter to disciplinary committee or disciplinary tribunal. So that is the other outcome. If the commission appears that there is something, but it does not constitute a disciplinary offense, it shall further notify the person of harm against the complaint has been made, acquire a person to answer the complaint such a reasonable period as shall specific is such by the commission. So that outcome is the advocate can be told to answer to the particulars. So outcome number 1, it can reject or dismiss. Secondly, it can be referred to disciplinary if it is serious disciplinary offense. If it is not serious disciplinary offense, tells the advocate to reply, and the hearing will happen. 53(5), in all cases which are commission be serious or given nature, the commission shall endeavor to promote reconciliation. So another outcome is reconciliation. Both the advocate and the client can be reconciled. 53(6), if the commission considers the complainant has suffered loss or damage, the commission may order B, compensation or reimbursement not exceeding 100,000 shillings. So those are 5 outcomes I have discussed. 53, 5, 4, 5, and 6 of the Advocates Act. Yeah. So I got to the last question of the day. I'm going to share. I'm sharing now question 6. So I'm going to read question 6, November 2023. So your people at the firm of XYZ Advocates. The firm has been provided legal services to Jing Jinping's, a Chinese manufacturing multinational corporation on the basis. Jinping is keen on entering into a retainer agreement with the firm. The managing partner of the firm has requested you to draft the retainer agreement for their review. As you commence the task, you recall your law of contract classes, including the fundamental principle of freedom of contract, in quotes, in the context of liberty to parties to incorporate their own terms, conditions in commercial agreement, highlight the terms that you are prohibited from incorporating in the retainer agreement despite the principle of freedom of contract. Yeah, so what are the things that are not supposed to be in the contract? A retainer. So this question, in other terms, is testing a candidate on discussing invalid agreements under Section 46 of the Advocates Act. Yeah. So we have dealt with different components of Section 46 of the Advocates Act. But previously, no question have been tested on Section 46 on its complete. So I'm going to share the Advocates Act. Basic, you must understand the Advocates Act. So those are 5 points, you give 5 points. 5 marks, you give 5 points. What are invalid agreements? So this retainer agreement must not have Section 46A of the Advocates Act, any purchase by an advocate of interest or any part of interest of his client in any suit or other contentious proceedings. 1 mark. B, any agreement reviving an advocate from responsibility for professional negligence or any responsible to which he would otherwise be subject as an advocate. 2nd mark, any agreement by which an advocate retained or employed or prosecute or defend any suit or other contentious proceedings period for any payment only in event of success in such suits. Point number 3. Success in such suits. 4th mark, or being remunerated at different rates according to the success or failure. So you cannot be paid only in event of success or be paid higher because you have won the case. 4 marks. Then 5th mark, any agreement 46D which an advocate agreed to accept in respect professional basis for any fee or consideration which shall be less than what is prescribed in the advocate's remuneration order. So those are 5 points. They are case law in year 2019 to support A, B, C, all these points. You do that, or you can find your own cases. This is a tested area. Every part is tested, A, B, C, and D, substantially on its own in the past. Read and acquit yourself with that. So the last question of the day, 6B. Upon your admission to the bar as an advocate of High Court of Kenya, you are employed as GCP Enterprises as legal manager. What are the effects of the regulation and ethics of professional conduct with regard to your duties and responsibility as a legal manager at the corporation? So what is your duties? What is the effects of regulations? That is, you underline that, and the ethics of professional conduct with regard to your duties and responsibility as a legal manager. 5 marks, you give 5 points. Question again never tested since 2008. Related to this question is a question on in-house law counsel in a non-legal entity. Question 2, November 2019. The answer is found in year 2008 to 2019 Q&A. So answering this question, point number 1, adherence to Code of Ethics of Advocates, SOPEC, Standard of Professional and Ethical Conduct 2017. Because the question is asked, what is the effects of regulation and ethics of profession as regard? So you must adhere. As an advocate of High Court of Kenya, the Code of Ethics issued by LSK govern your professional conduct. These rules apply you even in your private practice, but also when someone is employed in a corporate settings. You can discuss rule 2 of it, which are advocate to uphold rule of law, integrity, the rule that requires an advocate to maintain client confidentiality, etc. Point number 2, corporate governance and compliance. So, your role as a legal manager requires ensuring company adheres to relevant rules and regulations that govern corporate operations. In this capacity, the Companies Act and other regulatory frameworks, including Competition Act, Environmental Management, Section 1, the Companies Act includes impose a duty on legal officer to ensure that corporations comply with all applicable rules and regulations. As a legal manager, you need to ensure compliance with corporate governance structure, legal frameworks, and ethical conduct. Conflict of interest. As a legal manager, you must be vigilant about conflict of interest, especially if Jing Enterprise deals with multiple stakeholders or business partners. SOPEC requires you to back in the best interest of the employer and avoid situations where personal interest might conflict with your company. Duty of independence and professional judgment. You are all required to exercise independent professional judgment, even if when working for a corporate structure. While you serve the interests of Ginseng P enterprises, you must ensure that the legal advice you provide is objective, professional, and consistent with the law. Another point, subject to disciplinary mechanism. Even if as a corporate employee, as a legal manager in that company, you are accountable to the Advocate Disciplinary Tribunal and SK for any breaches of ethical conduct, misconduct in the corporate setting. Yeah. And you can be taken to the disciplinary. So those are the points in this case, in this question 6B. You explain. You may even get case laws. SOPEC has also spoken on that. You can quote the rules. You get your 5 marks and you are good to go. Yeah. So thank you very much for watching. Subscribe to the channel. Take action on what I've said. Make notes. And God is going to bless you. All the best as you prepare for the exams. Next video is April 2024, Professional Ethics, Part 1, which I'm going to deal with question 1, 2, and 3. Thanks. Bye.